Thank you very much. There's an extraordinary energy in the room, and no doubt in anticipation of the next two panels. But first, we have our first panel on Indigenous justice. We are very proud to have secured our three speakers. The chair is the Honourable Chanston Paech, MLA, the Attorney General for the Northern Territory, and the Minister for Justice. As well, we are joined by Her Honour, Justice Dina Yehia from the Supreme Court of New South Wales, and of course, Mr. McAvoy, SC from Frederick Jordan Chambers. That's it for me, and over to you, Chansey. Thank you.
Good afternoon, everyone. Look, it's an absolute honour and a privilege to be with you all today, and it is incredibly important that I acknowledge the wonderful country that we're meeting on this morning, the Gadigal people of the Eora Nation, and pay my respects to the leaders past, present and emerging, and certainly extend the thanks to Uncle, who was with us today, as a fellow First Nations person from the Gurindji and Aranda nations in the Northern Territory. I understand and acknowledge how important it is that we acknowledge country and we acknowledge our First Nations people at every opportunity we get to ensure that we are rightfully recognising the role in which they play in our community and in our everyday life and their places of deep cultural and spiritual significance. You have heard that we'll be talking about Indigenous justice today. I am the Northern Territory's new Attorney General. I have been in the role for 9 months and certainly have a lot more grey hairs in the 9 months than I have in the years before that. But I will say from the onset, the last 9 months have been an absolute honour and a privilege to take on the role as someone who people would often refer to as progressive, or if you're on the other side of politics, as woke. I wear them as a badge of honour because I have been able to drive long-lasting change in the Northern Territory over those 9 months, and that includes the Northern Territory being Australia's first jurisdiction to raise the age of criminal responsibility from 10 to 12, with a 2-year review period to make sure that the service systems are in place to transition to 14, and that will commence this year in June. The Northern Territory as well has typically had the broadest mandatory sentencing provisions in place for a number of years, and in October and December last year we were able to work through the Northern Territory Legislative Assembly to repeal those mandatory sentencing provisions because I will say, as a First Nations person and as a person who took on the role of Attorney General and Justice and walking through, I'm also the Minister for Correctional Services, so walking through the prison system and having your own relatives waving at you behind the bars, thinking that you were there to visit them, only to find out that you are the Attorney General, then being inundated with requests for pardons, was an interesting task, I have to say. But again, it brought home for me, I'm not a lawyer by profession. My background is environment. So I've been taught to base things on evidence. And that has put me in a very strong position in this area to base everything that I do for the law reform to be based on evidence. I know you've heard from Anne-Marie just before, and she's up the front giving me a big smile. I have to say, Anne-Marie, it's been wonderful, certainly, to have a friendly shoulder to lean on when I'm trying to navigate through my cabinet for progressive reform, and I think that that's certainly something that I'll touch on later. Just before we get into talking with my fellow amazing panellists, talk about some of the things that I think that we could do together. One of the things I want to do, though, is I want to make sure that you are engaged in this discussion as much as we are. So I'd like to pose a question to you all, which will allow some time to come back to at the end of this session, or if you are not comfortable, or as in the Territory, if you are too ashamed to talk about that in this forum, please jot that down on a piece of paper and leave it with us, because we would really like to make sure and understand where you feel there are some issues that we need to work with. So the question that we'd like to pose to you today as the audience is, what do you see as the single most pressing issue when it comes to Indigenous justice? So please mull over that while you are listening to the panellists today. And I think we will allow some time to come back. Again, if you are not comfortable, if we're running out of time, please leave that down so we can collate that and pass that on through the Institute for further panels and certainly for the research that we can do beyond that. We've heard earlier today, it's an opportunity to reflect upon the honour and incredible legacy of Gough Whitlam, a fearless leader who was instrumental in establishing legal aid, who believed in access to justice for the most vulnerable in our community. Gough Whitlam was also instrumental in driving a new approach to Aboriginal affairs, an approach grounded in self-determination. We've seen today, also by Anne-Marie, that iconic image of Whitlam pouring the sand into the hands of Vincent Lingiari as the traditional lands of the Gurindji people who were rightfully returned to theirs after years of struggle. And it's a timely reminder, ladies and gentlemen, to reflect on this, given the important conversations now happening on the Voice, Treaty and Truth, something I'm sure we'll return to in our discussion later. As I said, I've been through the Alice Springs and the Darwin correctional facilities, and for me, addressing the shameful rates of which First Nations people are locked up is personal. I've seen firsthand my own family locked up when they shouldn't be, locked up when they could have been referred to a program and diverted away from the criminal justice system, locked up because the law unfairly disadvantages them, locked up because of discriminatory practices ingrained in racism. And for those of us in this court, we know the reasons for contact in the criminal justice system are complex. They include poverty, intergenerational racism, and the ongoing impacts of colonisation. To reckon with these issues, I believe we have to decolonise the justice system. We have to put in place new foundations, new ways of working with First Nations peoples to make our justice system more fairer and more equitable. You may be wondering what I mean by decolonising the justice system. I mean working to dismantle systems that remain prejudiced towards First Nations peoples. I mean answering the call for structural reform in the Uluru Statement from the Heart. I mean ensuring that there are more First Nations people in positions in the leadership across our justice system, more First Nations judges and lawyers in our courtrooms across our country. And I often say to people, you can't be what you can't see. And for many of my First Nations brothers and sisters, often the only First Nations person they see in a courtroom is the person who's being escorted off to the prison system. I mean ensuring that the voices of First Nations people are heard through law and justice groups and Aboriginal sentencing courts, so we can value cultural information and knowledge as part of the sentencing process. I've previously called for a new age justice system, which considers the reasons that have led us to mass incarceration crises and acknowledge that there is no single solution. We need broader systemic reform alongside any law reform. I'm talking about addressing poverty, generational disadvantage, systemic racism and trauma. This approach requires a whole of government and society response. It requires agencies, portfolio areas, disciplines, and people to break down their silos and purposely choose to work collaboratively together. And that's where justice reinvestment comes in, because many of the contributing factors that lead us to the contact with the criminal justice system can be investing in people, not in new prisons. The federal government and the federal attorney spoke today about the commitment of funding to justice reinvestment initiatives in over 30 communities across Australia, which is an incredibly welcome and important step. This is a new age justice system on the way. Its leaders making it clear that the voice of Indigenous peoples are critical to achieving genuine change for our criminal justice system and beyond. The opportunity to be investing in programs that address alcohol and drug addiction, mental health, FASD, domestic and family violence, education and training, programs that will make a difference in our communities, on our country. This is an opportunity to work intensively with Aboriginal community-controlled sectors to increase their capacity to deliver those therapeutic programs on our country. The other important aspects of justice reinvestment requires funding. Regional and remote areas on a needs-based, not a population base. We want to see sound investments in evidence-based services and programs with self-determination at the heart of reinvestment. This, ladies and gentlemen, is the start of dismantling racial injustice and creating long-last generational change. I know that much of what has been spoken about today is certainly easier said than done. It's a journey, but we're starting to see positive change that will improve the outcomes for First Nations people. I think I've spoken probably enough right now. I am going to hand over to Tony to make some comments or talk, and then we'll pop over to Dina, and then we'll go out to you guys. Tony.
Thank you, Attorney. Thank you to John Faulkner and the board at the Whitlam Institute and John Jurians for helping to organise today. Thank you to Uncle Michael West for the very warm welcome today. It's an honour for me to speak on this occasion, and I have a few words that I'm going to get to, but having heard Anne-Marie's presentation, I have to say that it is really difficult for me to conceptualise what happens to my people as the delivery of justice. The injustice is sickening. It's sickening. The people that work in the industry are made sick by it. Our communities are made sick by it. What the attorney's talking about, having to go through the jails and have to see his relatives in jail, is exactly the same thing I had to do in 1983 when I started as an article clerk and I went to the cells in Brisbane. Exactly the same thing. I'd see my own relatives there and they'd be calling out to me. The justice system, as we call it in Australia, does not deliver justice to Indigenous people. And I can say this as somebody that's been in this system for a long time. Indigenous people see the justice system as something that is done to us. We are not a part of it. So there is a lot of work to do. And it's not just on the criminal sector, it's on the whole of the justice system. So having got that off my chest, I'll move on. And I have to say, I'm always encouraged by the attorney's optimism and hope and vitality, but sometimes I have to say, I was senior counsel assisting on the Dondale Royal Commission. I heard it firsthand. I'm the senior counsel assisting on the Europe Justice Commission, and we've just had hearings in Victoria where exactly the same sorts of racially discriminatory behaviour that we heard about in the Northern Territory is happening to Victorian Aboriginal people. Yesterday, I was at a meeting where Peter Yu from the Kimberley railed for 10 minutes about the fact that the area of Roebourne in Western Australia is one of the wealthiest postcodes in the whole of the world because of all the iron ore that is taken out of there. It's one of the wealthiest in one of the wealthiest countries. And the jail at Roebourne is 99% full of Aboriginal people. What does that say? Okay, moving on. So I did want to talk about Aboriginal legal services and the role of those services in the system. I am a beneficiary. I'm very proud to say, and I'm grateful to say, that I'm a beneficiary of the Whitlam government in two major respects. Firstly, I was the first person from both my Aboriginal father's side of the family and my European Australian mother's side of the family to be able to attend university, and that wouldn't have been made possible without the support for opening up the universities that the Whitlam government brought. Secondly, my first full-time job was in a firm that was retained by the Aboriginal Legal Service in Brisbane, Aboriginal and Torres Strait Islander Legal Service. So I went straight from high school into an Aboriginal legal service at the age of 18. So that was 1983. I wasn't there at the beginning of the Aboriginal legal service movement. That was 1970. I was probably in grade 1 or 2 when it started, but and therefore I wasn't there when the Whitlam government committed proper funding to legal aid. In I think it was 74, the legal aid commission funding came about in earnest. By the time I had started, though, the Aboriginal Legal Service in Brisbane had been funded for more than 10 years to provide Aboriginal legal services to Aboriginal and Torres Strait Islander community members in Brisbane. My observation of it now, looking back, is that at that time it was the political backbone of the community. It was the organisation that drove the marches and that drove the protest. It was the body that had that function within the community. There were housing services, childcare services, and other services, but the Aboriginal Legal Service had the political responsibility for driving the community. And I remember in 1983, my first year working at the Aboriginal Legal Service, that we organised a protest march for the death of John Paech, who had died that year in a cell in Western Australia. And I went to that march. I left Brisbane in 1994 and came to Sydney. When I left Brisbane, the street march and protest ethic had remained strong, and it still does to this day. It has moved, however, away from the legal service as that political backbone, I think, and it's with some sadness that I say that the pressure on Aboriginal and Torres Strait Islander legal services to corporatise and become more bureaucratic and figures and outcomes driven has meant that their capacity to be the political standard bearer for community outrage and resistance against governments has waned significantly. The protest movements have largely moved outside of the legal services and other community organisations, and it's a lot less structured at the moment, and it's sad that the legal service doesn't have the capacity to drive that protest, because what the legal service did, from my perspective, is the legal services drove those protests from a rights-based advocacy position. And what we've moved away to is something I think that is more pure resistance rather than rights-based. I have some hope, though. I've seen from my work in Victoria that in particular the Victorian Aboriginal Legal Service is making full use of the Victorian Charter of Human Rights and Responsibilities. And it was pleasing to hear the Attorney General, Federal Attorney General today, talking about the relaxation of the funding restrictions on advocacy. It's a very important shift because for many years Aboriginal legal services have been very cautious about what they say in public. We've also seen a restraint over the period that I've been talking about on the ability of Aboriginal and Torres Strait Islander legal services to deliver the tailored services our communities need. During my time at the Aboriginal Legal Service in Brisbane, which is on and off was about 11 years, there were no Aboriginal lawyers. The first Aboriginal lawyer admitted in New South Wales was Jackie Payne in 1986. But there was a very strong contingent of field officers. There were as many field officers as there were lawyers. They were all men in those days, and they were big men. I played football against a lot of them. They were big, strong men, but the problem was that that's what was needed. They were on call 24 hours a day, and they would get called to go out to the Inala police station or the Beenleigh police station or the Eagleby police station and go to at night on their own to a police station full of officers who were very antagonistic towards them. And their job was to see if they could get police bail for Aboriginal people and to make sure that the family knew that they were there and to help them get home if they needed to get home. The field officers really, in my reckoning of it, made all of the difference. They allowed the lawyers to communicate well, the non-Indigenous lawyers to communicate well with their clients. And if I had my way, and I was hoping the attorney was here, federal attorney, I would make sure that the Aboriginal and Torres Strait Islander legal services were and are continuously funded properly to have sufficient field officers who are well trained and well supported. Because apart from the direction that community boards are able to give, and I'm a director on the Aboriginal Legal Service New South Wales as of last year. The field officers, to my mind, are the distinguishing feature between Aboriginal and Torres Strait Islander legal services and the various legal aid commissions. They are the backbone and the strength of the Aboriginal legal service community. I also hold the view that Aboriginal and Torres Strait Islander legal services ought to be the incubators for our young First Nations lawyers and provide real career development options. It's a matter of some concern to me that I think, I haven't checked the figures, but I think the Legal Aid New South Wales has a higher ratio of First Nations lawyers than the ALS in New South Wales. By comparison, just going back to Queensland for a moment, I note that 7 First Nations magistrates have been appointed up there, 5 of which came through the Aboriginal Legal Service. I've worked with most of them, and so too did the recently appointed Supreme Court Justice Lincoln Crowley. And of course, I must mention that the attorney for the Northern Territory recently appointed my colleague and good friend, Judge David Woodruff, to the local court in the NT, and he was immediately prior to that appointment, he was the principal legal officer at the North Australian Aboriginal Justice Agency, NAJA. It's incredibly important, and I imagine that the elders who were on the board of the Aboriginal Legal Service when it was created and when I was there had this vision that the legal service would one day be staffed by mostly or all Aboriginal and Torres Strait Islander lawyers. And it's a shame that we haven't been able to deliver on that. But I will make an observation for those who have thought about how they might get Aboriginal and Torres Strait Islander young lawyers into their organisations. One of the things I realised is that as a Aboriginal person, as a First Nations person, it is incredibly difficult to work for the legal service in your own hometown. And so many First Nations lawyers don't do it. And in fact, I encourage young lawyers to go somewhere else because the trauma is too much to bear. Of seeing your family day in, day out, people you know, people you've grown up with, being subjected to what in many cases is a very unjust system. Finally, I wanted to say the reason that I was listening to Peter Yu yesterday was that I was in Canberra on the referendum working group meeting, at which the Attorney General was present for some of the day. And I raise it now because it's a very topical issue for all of us, and I'm here to say that this proposed reform to our constitution to allow us to be heard is a very important platform in terms of delivering a better justice system for us. I'll leave it at that. Thank you.
Thank you, Tony. Okay, we now ask Judge Yehia to provide some opening remarks.
Thank you, Chansey. Firstly, I want to also thank the organisers who have put together this wonderful afternoon and session. I want to thank Uncle Michael for his very warm welcome to country. This is a huge topic, Indigenous justice. There's so much to talk about. There's little time to talk about it all. Chris Ronald said to me before we started, make sure that you are witty and entertaining. I said to her I couldn't promise that, but I knew that my co-panellists would be powerful speakers, and they have been. It is a big topic, and I want to focus in the few minutes that I have on Indigenous justice in the criminal justice system, and focus particularly on what I find to be a very disturbing and continuing to be a crisis in this country, and that is the disproportionate rate of First Nations people in our prisons. I started my career as a 26-year-old solicitor at the Western Aboriginal Legal Service based in Dubbo and working in country towns in Western New South Wales. And over the last 3 decades or so, the one thing that I have seen change, disturbingly, is the ever-increasing number of Indigenous people in our jails, and in particular, and a particular concern to me, and I think for many in this room, the ever-increasing numbers of Indigenous women in our jails, with all the particular consequences that brings in terms of out-of-home care for their children. I should say that obviously I'm the judge on the panel. I'm one of those people that is bound by the laws as they exist, not what they should be or what I personally wish they were. And so I will speak within the confines of my role, recognising that I am one of those people who does impose prison sentences, sending Indigenous people to jail. I think that there are 3 points that I want to make in these introductory remarks. 3 areas where I think we can make improvement really within those confines. And the first is what I refer to as cultural authority. For the criminal justice system to really have any chance of making any positive impact in the lives of Indigenous people who come before that system needs to have cultural authority. And for so long it hasn't. I think one of the ways in which we can do better in that space is that we need to see more First Nations judges, magistrates, lawyers, caseworkers, court officers. I'm not quite sure why we haven't done better in that regard, but I think that it is essential. The second point that I want to make is this. We're not going to get the numbers down if we don't have the diversionary programs to send people to. We're just not going to do it. Sometimes, and I think those in the room who work for legal aid or Aboriginal legal services will recognise this. Sometimes there just isn't a diversionary program that you can engage in terms of an alternative to imprisonment. I've been there myself when I was an advocate. I see it now from the bench. It is very difficult. Sometimes people who are making bail applications or sentencing submissions have to tell the court that their clients are waiting 2 or 3 months before they can get a bed in a residential rehabilitation centre. That makes me ask the question, what does Justice Reinvest actually mean? And I would like to make a request that if anybody actually has the figures in respect of the money that has been reinvested into community-based programs as a result of Justice Reinvest programs, I'd like to see them, because it seems to me that that is a very important area that we need to think about. People talk about getting more resources, and that may be a legitimate request, but for me, I think we have the resources. It's just that we need to think of better ways of using those resources and diverting them into more meaningful programs, including diversionary programs. The third point that I want to make in these introductory remarks is this. Again, within the confines of the criminal justice system as it exists, I think that it's really important that we think about Indigenous sentencing courts. There have been initiatives by way of circle sentencing, for example, by way of the youth courts, youth Koori courts, and also in Victoria, the County Koori Court, and in New South Wales, the Whitlam list. And if you know anything about those courts, you know that they bring a very different approach to sentencing of First Nations peoples. I have had the experience of sitting in the Whitlam list, so I can speak about that through my direct experience. And that approach brings together cultural authority by involvement of elders, by involvement of Aboriginal caseworkers, by the involvement in New South Wales of the Aboriginal Service Unit, which is a unit of the Department of Communities and Justice that has the most talented individuals who support the Whitlam list. By involving grassroots Indigenous organisations in terms of the programs and the caseworkers that they have to offer. It seems to me that that's a much more effective way to approach at least that discrete area, sentencing, in the criminal justice system. It is much more powerful than anything that is done in the general lists or general sentencing courts. It does go back to the first point that I made, which is bringing cultural authority to the process. It increases the respect that the participants have in the process because it is culturally appropriate, not just in terms of the contribution of elders and the Aboriginal Service Unit, but also the types of programs that are available that are culturally appropriate programs. So those are the 3 points that I'd like to make within that discrete area of the criminal justice system, and I hope that we can open it up for discussion about that and many other topics.
Great. Thank you, Judge. There are roaming mics. Okay, so don't be shy. Anyone who has a question, there has to definitely, someone in the audience has to have a question for us, or even a response to the question we asked you.
If nobody asks a question, I'm going to cross-examine the attorney.
So someone please ask me. I've got a question at the front here.
Did you say there's a mic?
There is a
There was
mic.
someone
Yep,
with
it's
a
coming.
mic.
Thank you so much for such powerful and moving contributions. I completely agree with what you said about the sickening injustice, and thinking about the sort of ambition of Gov's government, I wondered what you thought the federal government could be doing to kind of show that same ambition, to really tackle the overrepresentation of Indigenous peoples in prisons, to end the detention of kids, and to decolonise the justice system. I wonder what you thought, what you think the federal government could do now that we, finally have Labor back in power. They should surely really use this opportunity.
There's a fairly long list of things. It's been getting stored up over a while. There was a report, Pathways to Justice, which came out from the Australian Law Reform Commission in 2017, which recommended very many of the same things that were in the Royal Commission to Aboriginal Deaths in Custody report from 1991. But just to be more direct, I suppose, the federal government could show leadership on raising the minimum age of criminal responsibility, get that done, make sure that we have proper monitoring systems under the OPCAT, and ensure that I think that there's a real role for the federal government in showing leadership around youth justice. I understand that there are constitutional issues, but in Canada, the federal government has responsibility for youth justice, and it seems to me that the measures that they're able to advance there are the uniformity and the levelling out of the system are really important. There are a lot of things we can learn from New Zealand in the way in which they do it. There's probably a dozen others.
I would, well, not really add, but just echo what Tony said in respect of the ALRC report, Pathways to Justice. I mean, I think the recommendations were handed down maybe 4 years ago. I'm not sure, 3 or 4 years ago.
I thought it was...
maybe longer now?
Yeah, November 2017.
I'm not sure that any of the recommendations have been acted on. And that report, it's quite a comprehensive report. It talks about many of the things that have already been discussed. It would be good to have some action in respect of those recommendations. And if I may say this, we've had royal commissions, we've had inquiries upon inquiries upon inquiries. As far as I know, most of those inquiries have had consensus in respect of what the recommendations are and what needs to be done. So I would say less inquiries, and let's perhaps action some of the recommendations.
I think going to your point, but building on from what Tony said, having a national approach to raising the age of criminal responsibility. I live in a jurisdiction where my family, they live in another state for 6 months of the year because we live in Central Australia, transient in nature. We need to be thinking about that young person at different times. There's different criminal responsibility now. There needs to be a national approach. I think we have a Commonwealth Albanese government now. Let's not be afraid to actually talk about investing in people and not in punitive draconian measures such as prisons. I think that's one of the biggest things. If tough on crime worked, Australia would be the safest country in the world, because we talk about it. We want to look like we're out there with it, beating our chests, saying we're doing this, we're doing this. The only thing we're doing is depriving an entire generation of identity by continuing to lock people up, because it does not work. If it worked, we would have seen results now. So I guess my response would be, let's not fall into this trap of pandering to a political narrative of saying we have to do this. I mean, justice reinvestment itself is an Americanized model that has been driven in large parts by Republican states, and it works. We've seen it work. We've seen it work here in Bourke, Moree. The Commonwealth Albanese government have absolutely made a commitment of $79 million across 30 states. Is that going to be enough? Probably not, but is it going to be enough to get state and territories on that journey to do it? Yes, but obviously to Judge Yehia's point as well, that's where it gives us the tools to actually demonstrate to the wider community that this model works, because the younger you get someone into the criminal justice system, you start their apprenticeship in a lifelong connection with the justice and the criminal system that is almost impossible to free someone from.
I might just add that the principle that underpins the justice reinvestment model in Australia is the principle of self-determination. And this government, federal government, appears to me to be committed to trying to honour and provide for self-determination in various forms. And unfortunately, I think that this referendum will turn out to be a referendum on self-determination. And if we lose it, then it will be used against us to say that the self-determination has been rejected by the Australian community.
Any other questions? There's one up the back, or two, three. Oh, look at this. I'm loving it.
Thank you, and thank you for your very earnest contributions. And Your Honour, this question might not be something that you can comment on, but I'd love to hear what you might say on it, but I won't put you on the spot. I can put it to anyone
Turn the
else.
cameras off.
And your phones.
Your Honour's work in social disadvantage and development of the common law and that doctrine has obviously goes without saying, but the Crime Sentencing and Procedure Act has little, as I understand, nothing by way of statutory recognition of social disadvantage. By that I'm talking about the Bugmy factors. I'm wondering if there's been any comparative examples in other states, or if there's any position that you wish to comment upon in introducing a statutory codification of those considerations, because ultimately your discretion then gets limited by the normative concepts that we've espoused in the common law. So I just thought I'd open that up, and I know that Your Honour might not be able to speak to that fully, but I thought I'd ask that generally.
Well, I think I can answer it safely in this way. There is nothing in the Crime Sentencing Procedure Act New South Wales that mandates that a judicial officer has to take into account the particular circumstances of Aboriginal people in the same way that the Canadian Criminal Code does. As a result of that, in the High Court decision of Bugmy, that most of you will be familiar with, and I was the lead counsel in that case, we lost the argument, although we won the appeal, but we lost the argument about judicial officers being directed to have regard to the unique systemic disadvantage of Aboriginal people as a result of colonisation and dispossession. And we lost it on the basis that the High Court distinguished the Canadian authorities because in Canada there was a specific provision in the code that said that judicial officers had to have regard to the circumstances of Aboriginal people.
Do you want to add anything, Tony?
So I am not advocating a position as a judge. I put that before you as an observation of what might be required.
Thank you for the observation, Judge.
I might.
Tony might be.
I'll just add that there was a New South Wales Law Reform Commission inquiry into whether such a provision ought to be added, and I read it some time ago, and I know that the now past former District Court Judge Bob Balia was a strong advocate for that type of provision in the New South Wales legislation, but it ultimately didn't go ahead, and we ended up in the position we're in now, relying on Bugmy.
And I think, I may be wrong about this, but I think the ALRC report, the Pathways to Justice report, also looked at that. They may have recommended such a provision.
There was another question at the front here.
Thank you guys for, first of all, just being here and sharing what you guys have to say about this issue. Tony, based on what you said about, this issue being sickening, and me being a uni student studying law and criminology, I've just finally grasped the understanding of the issue and what's what the issue is actually.
Tell me what it is later.
Sorry, tell me.
I'm not sure.
Yeah, because since I was young, would be taught the issue and why it's wrong and what needs to be changed. But so we're all aware of it, but clearly there hasn't been, much of a change, or there has been, but it's very slow over time. Do you think, I guess this is a question for everyone, but do you think there needs to be an emphasis on education, not just in schools and universities, but within the legal profession, with police officers, with, any member of parliament that, I get we have all our differences and we have different opinions on it, but yeah, do you think there should be more of a reinforcement and a push with legal professionals in regards to education on the issue? Because I feel like it's been more implemented in universities and schools, but legal professionals don't understand fully. I could be wrong, but
No,
yeah,
you're entirely correct. And yes, absolutely. Absolutely. It's a discussion that I chair a committee, the Indigenous Legal Issues Committee of the Law Council of Australia. It's an issue we've canvassed a number of times about whether there ought to be mandatory CPDs for practitioners in terms of Indigenous cultural competency. There's always the pushback against mandatory CPDs, but there's a very strong argument to say that the levels of injustice warrant that type of response. In addition, there's movements to try and change the undergraduate law degree so that it is far less coloniser focused. And there's a lot of work that's been done in New Zealand on indigenisation of the undergraduate law degree, and they are talking there in terms of a bijural legal system in New Zealand. And if you ask me, having practiced in native title law and treaty business, I can tell you there are definitely more than one system of law operating in this country. And Australian lawyers don't get that. Australian law students don't get that unless they've had direct exposure. And so there is a huge educational role, and I'd like to think that the role that the truth-telling commissions, there's the one that has commenced already in Victoria, Queensland's just committed to one. They will have a very important role in educating the community as a whole. And this is not meant to be confrontational for anybody here, but there was a study that came out 2 years ago which found that 3 out of 4 Australians had a negative, unconscious or implicit bias against Indigenous Australians. And if you accept that that's correct, then you've got to question the ability of the justice system to deliver justice to Aboriginal people. You from the very outset, when the police are involved, right through to parole decisions. And so there's a lot of work to be done. I think probably, I'll be quick. I think probably though, Collingwood in Melbourne is probably the most culturally safe place in Australia. I had a day off from the York Justice Commission, and I was walking down the street with a T-shirt with a map of Australia and an Aboriginal flag colour on it, and there were all these white people walking the other direction. It's Collingwood, and they'd look at my shirt and they'd smile at me, and I'm going, "What's going on?" Usually I'm met with sort of stern looks, but they're all very, very friendly, and it felt to me like the sort of feeling I get in Wellington or Auckland. That the level of respect is entirely different, and if you're on this side of the equation, it's palpable. And you know, I'd like to think that we could get to a point where we feel culturally safe wherever we are. Oh, that's a long answer to your question. It's a big question.
Sorry, can I just add, just in answer to your question, I'm sorry I don't know your name, but I think education is very important, and I agree with you. I think that it needs to start in school. But in terms of educating the judiciary, there are some really positive moves in New South Wales through the New South Wales Judicial Commission, and in particular the Nara Yura Committee, which is a committee of the New South Wales Judicial Commission. And it organises events, excursions, First Nations speaking series to educate judicial officers and the profession more broadly. I would encourage any judges and or practitioners here to sign up for those events and come along, because I think it's a really important way to learn, and we all need more education.
I think we've probably got time for one more question, but just in response to your question, I think it's really important. Just because you do one cultural awareness training session does not make you an expert in blackfella affairs. We are not homogenous people. Different states, different jurisdictions, different cultural competencies and knowledges. So that's really important. Constantly, if you move state, move borders, familiarise yourself, educate yourself around those. I think that's really important. And again, it just goes to that overarching piece that we've been discussing around dismantling the colonial view of what justice or justice should look like in this country. And that starts with working with our leading tertiary education facilities to incorporate those knowledge-based systems that were the first laws of this land that were by First Nations peoples. So we do have time for one more question, and now all the hands pop up. I think we've got one just at the front here.
Mark Robinson, I'm a barrister in Sydney. I'm also appointed a member of the Disability Council of New South Wales. It's a comment really. Just a few weeks ago we adopted a project to look at justice and in New South Wales for disability people who go through courts and tribunals, and we decided the prison system as well. And the reason I mention that, because we're going to be looking at all issues involving people with a disability, and it includes cognitive impairment, is a large percentage of these people are Indigenous people as well. So we're going to be rubbing up against the issue over the next few months. The government has to listen to us because the statute says they have to listen to us, which is nice. But we're not a royal commission. We're just 10 or 12 people, each with a disability, and we're doing the best we can. But we're working on that now. Thank you.
Great, thank you. Just before we finish, I'm going to annoy the organisers a little bit. I apologise. I do like to rock the boat a bit. We did ask you a question earlier and I'd like just to throw to the audience if anyone is comfortable in answering that question that we asked. There's a hand up the back. We've got a mic coming right now for you.
Hi, my name is Ruby. I'm a First Nations student from Western Sydney University. And the answer to the question about the single most pressing issue in regard to Indigenous justice for me is that the person who sits in that chair up there does not understand the complexity, nuance and history of the Aboriginal identity. If you don't know who you're judging, then you don't know how to judge them, I think. And I don't think that it's necessarily fair that Aboriginal children and Aboriginal women can be punished, and Aboriginal men can be punished for their suffering. And I think that it goes to, again, just the lack of understanding of the Aboriginal identity. So, yeah.
Great, thank you for sharing. And can I do one more? Yes. Gentleman up the back with your hand. Thank you.
Thanks very much, Jonathan Hunyo. I think I'll cheat and say that I think Tony's given us the answer to the single most important question, and there have been a number of examples throughout the presentations, but it is how do we shift power so that the justice system isn't happening to Aboriginal people? I think the voice offers us one answer to that. Involvement of Aboriginal people in things like Whitlam Court may give us another answer. Having more Aboriginal people on the bench gives us an answer. But if we're not shifting power, then we can possibly stop making things so bad, but we're never going to make things better. And I think that's the question we should be asking every time we think of a reform, is does this actually help shift power?
Right. Well, ladies and gentlemen, we are going to finish this session, and I'll finish on one of my most favourite quotes from the none other than Goth Whitlam himself. Ladies and gentlemen, please maintain your rage and enthusiasm, because progressive reform isn't easy, and we need you all to keep that fire burning in your belly to see the injustices dismantled and to see this country a more fair and just nation. So, ladies and gentlemen, thank you very much for your time, and please get those questions to us.